Hello everyone. Welcome to our YouTube channel for Clat and other law exams. So today, as you can see on the board, today we'll be discussing about some maxims of tort. So we all know about Law of Torts, which is a very important subject for any law entrance exam or wherever you go, may it WBCS, may it UPSC, everywhere Law of Torts is very important. So today we'll be discussing about some maxims of Law of Torts. So as you can see on the board, we have a new maxim, ubi jus, ibi remedium. So we have a maxim here. So now what is the meaning of this maxim? So let us understand what does this maxim mean. This maxim, the literal meaning of this maxim is where there is a wrong, there is a remedy. So what is the meaning of this maxim? This maxim means where there is a wrong, there is a remedy. So every wrong has some remedy. Our law provides every wrong a remedy. So law provides a remedy for every wrong. Okay. Now the law of tort is said to be the development of the maxim ubi jus ibi remedium. So law of tort is called the development of this maxim. Okay, so basically law of tort depends on this maxim. Law of tort, the essence of law of tort is this maxim. So law of tort says that where there is a wrong, there is a remedy. So basically I should say where there is a legal wrong, there is a remedy. Now, what is the meaning of this? Where there is a wrong, there is a remedy, and where there is a legal wrong, there is a remedy. So, this maxim says there is no remedy without any wrong. So, in another way, we can also say that where there is no remedy, there is no wrong. Okay. Now, we will see. I said that where there is a legal wrong, there is a remedy. Now, this maxim does not mean that there is a legal remedy for each and every wrong committed. Just suppose let me say there can be any wrong. So this maxim does not say that there is a remedy, there is a legal remedy. There is a legal remedy for each and every wrong. So, each and every wrong is not falling under the category of this maxim. So, there are some respective wrongs that are falling under this maxim. So, it is appropriately said by Justice Stephen. So, Justice Stephen has mentioned that maxim would be correctly stated if maxim were to be reversed to say that. So, we will be getting the correct meaning of this maxim if we reverse the meaning of the maxim. So, what should we do then? Where there is no legal remedy, there is no legal wrong. So, if there is a legal wrong and if there is a legal remedy, then only legal wrong exists. And where there is a legal wrong, only there a legal remedy exists. Okay. So, where there is no legal wrong, no legal remedy can exist there. So, basically everything should be legal. If your legal right is not violated, you are not going to get a legal remedy in case of law of tort. Okay. So, if your legal right is not violated, you are not going to get a legal remedy in law of torts. So, basically we can say that where there is a right, there is a remedy, or specifically we can say where there is a legal right, there is a remedy. So, where there is a legal right, there is a remedy. So, if your legal right has been violated by any individual, then you can get a legal remedy under law of tort. So, this is the meaning of the maxim ubi jus remedium. Okay. Alright, so what is next? See, here are some essentials of this maxim. Here are some essentials. So let us go through the essentials. The maxim can be applied only where the right exists, and that right should be recognized by the court of law. So it should be a legal right. What is the meaning of this first sentence? What is the meaning of this first para? It says that this maxim only exists where there is a right which is recognized by the court of law. There is a right which is recognized by the court of law. That means it should be a legal right. Okay, so then only this maxim is going to work if the right is legal in nature. Next is what? A wrongful act must have been done which violates the legal right of a person. So there has to be a wrongful act. There has to be an action which was wrong in nature. So the defendant has to do something wrong. Only then your legal right is violated and you are liable to get legal remedy. Okay. So next essential is, number 2 essential is, there should be a wrongful act. Okay. What is number 3? This maxim is applicable if any legal injury had been caused to any person. So this maxim is applicable where legal injury has been caused to a person or to a plaintiff. Legal injury has been caused to the plaintiff by the defendant. So injury also should be legal. Your right should be also legal. Your legal right violated, that means legal injury caused to you. Your legal right violated. So what are legal rights? Fundamental rights are your legal rights. So anybody violating your fundamental rights, they are your legal rights. So nobody has the permission to violate our fundamental rights or our legal rights. Then if my fundamental rights are violated by any individual, I can sue him under law of torts and I can get legal remedy. So this is about the essential of this maxim. So let us see what is next. Next we can see there is one more maxim which is also the essence of the law of tort. Okay, this is also the essence of the law of tort. Okay, law of tort says that this injuria sine damnum. What does this mean? Injuria means injury. Okay, damnum means damage. Alright, so what is the meaning of this maxim? Legal damage without any injury. So this maxim means there is legal damage but without any injury, means your legal right has been violated, okay, but there is no physical injury. No injury has been caused to you, but your legal right has been violated. Okay, legal right violated, but no sort of injury, harm or loss. Okay. So let us see what are the points. No damage, harm or loss has been caused to the plaintiff, but he has suffered injury. So there is no sort of harm, loss or damage caused to the plaintiff. So there is no harm caused to the plaintiff by the defendant, but plaintiff's legal right has been violated. Okay. Number two is plaintiff need not prove the damages, but he has to prove that some legal injury has been caused to him by the act of the defendant. So the plaintiff do not need to prove that how much damage has been caused to him by the defendant. The plaintiff do not need to prove this. The plaintiff only needs to prove that legal injury, legal damage has been caused to the plaintiff by the defendant. So what is legal damage? My legal right has been violated. That is legal damage. So the plaintiff needs to prove this. Alright. Let's see the next point. So the injury suffered by the plaintiff is not a physical injury. So the plaintiff did not suffer any physical injury. Okay, so what kind of injury it is? It is a legal injury, that is violation of my legal right. That doesn't mean that I have a physical injury, okay? But the legal right of the plaintiff are violated. So legal right of the plaintiff are violated. That is his legal injury. No physical injury is involved in this case. Okay. What is next? Compensation is awarded to the plaintiff for the loss caused to him. So what is the remedy in case of tort? So what is the remedy that I am supposed to get when my legal right is violated? So always in law of torts, the remedy that I am going to get when my legal rights are violated are only compensation, in terms of money. Okay, in terms of money, that means I am going to get monetary compensation from the court. That court will award me monetary compensation that defendant has to pay me. Court will award me monetary compensation because of the legal damage that I suffered by the defendant. Because of the defendant I suffered legal damage. The court is going to award me compensation, or you can also say damages. Okay. You can also say court is going to award me damages in terms of money, or monetary compensation I am going to get. Okay. Next you can see a case law. That is Ashby versus White. So what happened in Ashby versus White? In Ashby versus White, let us discuss the case. What happened in Ashby versus White? So in Ashby versus White, okay, there was a parliamentary election going on. And plaintiff was a voter. Okay, plaintiff was a voter. Rather, I should say plaintiff was a qualified voter. Okay, plaintiff was a qualified voter. So a parliamentary election was going on and the plaintiff was a qualified voter. Now who was the defendant? Defendant was a police officer. Okay. Now what happened here? A parliamentary election was going on, plaintiff was a qualified voter and defendant was a police officer. Now what happened in this case? In this case, the defendant did not allow the plaintiff to vote in that election. Defendant did not allow the plaintiff to vote. So the right to vote has been vested by us, has been vested upon us by the Constitution. Okay. So we have the right to vote. It is our fundamental right. Okay. That we have got from the Constitution of India. It has given us the right to vote. Okay. We have got the right to vote and I am a qualified voter. So I should be given to vote. Okay. Nobody can restrain me from giving my vote to my preferred candidate. Okay. Nobody can restrain me. Now what happened in this case? This police officer did not let the plaintiff to vote in that parliamentary election. The plaintiff sued the police officer and the plaintiff alleged that he said that as my legal right was violated, I was not let to vote in the parliamentary election, I must get compensation from the police officer. I must get damages because my legal right was violated. Okay. So what happened in this case? What was the judgment in this case? The Supreme Court said that as there has been legal right, violation of a legal right was there. Parliamentary election and the right to vote was a fundamental right. Okay, it was violated by the defendant, the police officer. He did not let him vote in the election. So that is violation of plaintiff's legal right to vote. Okay, so the court granted damages to the plaintiff. But the defendant said that, the defendant argued that, now what happened? The candidate whom the plaintiff wanted to vote, the candidate whom the plaintiff wanted to vote won in that election. So the defendant argued that the plaintiff wanted to vote this candidate and this candidate only won the election. So what is the injury? Where is the injury? Where is the damage? Where is the harm? Where is the loss? There is no loss that caused to the plaintiff because he wanted to vote for this candidate and this candidate only won the election. So there is no loss that caused to the plaintiff. So defendant argued this, but the court said that, okay, there is no harm. There is no harm, no injury caused to the plaintiff, but his legal right, that is his right to vote, was violated. Okay, so this is injuria sine damnum. That means no injury, but legal right has been violated. Okay, so I guess this was clear. Now let us see another maxim. So what is it? It is damnum sine injuria. Okay, it is damnum sine injuria. So what happened in this case? What is happening in this case? In this case, injury is there. Okay, injury is there. That means harm is there, loss is there, but no violation of legal right without legal damage. There is no violation of legal right, just the opposite of injuria sine damnum. In injuria sine damnum, we saw that violation of legal right was there, but no injury. Okay, but in damnum sine injuria, there is injury, but no violation of legal right. Okay, so what are the points? Let's see the points. Okay, let's see the points. Alright, so what is it? No injury has been caused to the plaintiff, but he suffered damage. So, no injury has caused to the plaintiff. So, there is no violation of legal right, but the plaintiff suffered damage. Okay, no violation. The plaintiff's legal right was not violated. Okay, the plaintiff's legal right was not violated, but he suffered damage, he suffered loss. Okay. He suffered loss because of the act of the defendant. Okay, because of the act of the defendant, the plaintiff suffered loss. So what is the next point? The plaintiff's legal rights are not violated. Yes, this was the thing. So the plaintiff's legal right was not violated. Okay, but he suffered damage. Next is what? If legal rights are not violated but injury has been caused to the plaintiff, they are not actionable unless there is a legal right present. So, unless there is a legal right, you cannot claim damages from the defendant. Unless there is a legal right, it is not actionable in the eye of law under law of torts. If legal rights are not violated, you cannot claim damages from the defendant. So, no action can be taken by the plaintiff against the defendant if there is no violation of legal right. Okay, so in this case, we can see one case law. We can refer to one case law to understand damnum sine injuria much better. So what is this? This is Gloucester Grammar School case. So what happened in Gloucester Grammar School case? Okay, in this case, defendant was a schoolmaster and plaintiff was a school. Okay, rather I should say a reputed school. Okay, plaintiff was a reputed school and the defendant was a schoolmaster. Okay, so what happened? Set up a school. The defendant set up a school adjacent to, just adjacent to the school of the plaintiff. So what happened? The defendant set up a new school. Okay, the defendant set up a new school just adjacent to the school of the plaintiff, which was a reputed school. Okay, which was reputed school in that area. The plaintiff school, the school of the plaintiff was very reputed. Okay, so it was very famous. But what happened? The defendant set up a new school. As he was a schoolmaster, he set up a new school just adjacent to the area of the school of the plaintiff. Now what happened? A competition arose there. There was a competition because only the plaintiff school was present beforehand, but now there is a new school. Okay, there is a new school which is looking very good. Okay, which is giving us facilities, giving the students much more facilities than the school of the plaintiff. So there was a competition here now between the defendant and the plaintiff. Both schools are competing. Now what happened? The plaintiff sued the defendant. Okay, the plaintiff sued the defendant. Why? Why the plaintiff sued the defendant? Because the plaintiff suffered loss. Why? The plaintiff had to reduce the fees. Why? Because there was competition going on. If you don't reduce the fees, I will go to the next school. Right or wrong? So I will go to the next school if you don't reduce your fees. So the plaintiff was facing reduction of fees and the plaintiff was suffering loss due to that. Okay, so that is why plaintiff sued the defendant. That the plaintiff alleged that due to the construction of the new school, the setup of the new school by the defendant, I am suffering loss. Okay, so this was the problem that the plaintiff was facing. But what did the Supreme Court say? The Supreme Court said that there is no legal damage. So no violation of legal right. So did the defendant violate any legal right of the plaintiff in this case? He just set up a new school. So by just a construction of new school, is the legal rights of the plaintiff violated? No, absolutely not. The legal rights of the plaintiffs are not violated. Yeah, you can say that the plaintiff was suffering harm, the plaintiff was suffering loss by the construction of the new school of the defendant, but the legal right was not violated. No legal right was violated of the plaintiff. So in this case, the court held that the defendant cannot be held liable or no compensation should be paid to the plaintiff by the defendant. So the Supreme Court was of this view that the defendant is not liable in this case. Okay. So this was about Gloucester Grammar School case. Okay. So we have come to the end of our class, and I hope you liked the maxims, and please like our channel, please like the video and subscribe our channel, and please watch our other videos for it will help you in your law preparation. And thanks for watching. Thank you.